Welcome to the overview of the Immigration Services Act. The Act came into force July 1st, 2024, and the new regulations are in development and will be implemented in the coming weeks. Over the last 25 years, the Saskatchewan Immigrant Nominee Program, the SINP, has transformed from a modest pathway for economic immigration to become one of Canada's leading provincial nominee programs. It has played a crucial role in supporting Saskatchewan's growth plan. With growing demand for immigration and more employers using the program, there is an increased risk and public focus on fraud and misrepresentation. Therefore, we developed the new Immigration Services Act to replace the existing legislation, the Foreign Worker Recruitment and Immigration Services Act. The introduction of new and robust immigration legislation in Saskatchewan will strengthen our immigration legal framework, making the immigration system in Saskatchewan both safer and more attractive for newcomers. The new Act brings all immigration authorities in Saskatchewan under one piece of legislation and will better enable the province to respond to changing needs in the immigration system. It will improve our ability to support newcomers, simplify the process, and establish the strongest program integrity framework in Canada. It also allows us to provide increased support to newcomers settling here, from pre-arrival to long-term retention assistance to ensure they stay in the province long-term. The new Act also enables greater autonomy over immigration. It includes increased investigative authorities, stronger enforcement measures, and new authorities over settlement services, representing another step towards our goal. A robust and effective immigration system will create a positive experience for newcomers and lead to better outcomes for the province. Our immigration programming will continue to build on current successes, help meet employer demand, and contribute to the growth of Saskatchewan's population and economy. Main components of the new Act. The new legislation contains many parts of the Foreign Worker Recruitment and Immigration Services Act, at the same time enhancing our immigration integrity framework to further protect foreign workers from exploitation by strengthening oversight of foreign worker recruiters, immigration consultants, and employers. Clarify that the individual's license does not extend to employees to improve oversight of foreign worker recruiters and immigration consultants. Expand the authority to suspend or cancel a license or registration based on compliance with the Act and regulations. Allow the Ministry to publish a registry of employers on our website. These are a few examples of increased oversight. The Act also provides the authority to prescribe a new application fee for recruiter and consultant licenses in the regulations. It also provides enhancing information sharing authority so we can share information on investigations and increase our collaboration with other enforcement agencies. There are also components in the Act that complement the Protection from Human Trafficking Act, such as prohibiting situations in which foreign worker recruiters, immigration consultants, or employers use any information, documentation, or decisions provided for or by a selection program as leverage for financial gain, or expanding the compensation order to include situations where an employer receives money from a foreign worker for a job offer or approval by a selection program. Another component of the Act is increasing investigative authority and enforcement measures to address immigration fraud, such as increasing the maximum fine amounts for individuals to $750,000 and for corporations to $1,250,000. The Act also provides new authority for the Ministry to prescribe administrative penalties in the regulations. Administrative penalties will be used in situations where court charges are not required. For example, for more minor non-compliance issues applicable to individuals or corporations. We are considering prescribing a maximum administrative penalty of $200,000 for individuals and a maximum administrative penalty of $400,000 for corporations. We're also expanding the authority to provide our enforcement staff with peace officer status to conduct inspections and investigations, so staff can get a search warrant and production order. The new Act also contains a few new sections to formalize the Ministry's responsibilities regarding recruitment and immigration services and programs. It reinforces the Ministry's authorities to carry out international recruitment, and the Ministry will also have the authority to provide settlement services from pre-arrival to longer-term retention. The new Act further provides the authority to establish a selection program, like the SINP, to select international workers for admission to the province as permanent or temporary residents. Accompanying changes. New email domain changes have already been implemented to support the integrity of our immigration system. When supporting employer recruitment, job approval forms require submission from an SIMP account linked to an employer's custom domain email or a Canadian telecom provider's email. Generic email providers like Gmail or Yahoo are not accepted for integrity reasons. The authorization email on an employer's account must be the employer's email. The correspondence emails on an employer account must match both the employer and immigration recruiter's emails. For financial security, when the new act comes into force, only surety bonds and letters of credit will be accepted as forms of financial security from foreign worker recruiters and immigration consultants. Any new financial security submitted on and after that will need to comply with this new policy. If you have already submitted your financial security, you will not be affected by this change. The new act provides the authority to provide a new application fee for recruiter and consultant licenses in the regulations. The new fees for recruiters and consultants align with a cost recovery approach that supports Saskatchewan's immigration system, bringing Saskatchewan in line with other jurisdictions. These fees support enhanced program integrity efforts to ensure compliance with legislation and help support continued investment into the online application system and its related technical systems. It is illegal to pass on the cost of these fees to clients. If you have already registered with the Government of Saskatchewan, you will not be affected until you renew your license. We are considering $300 for a new license, which is valid for 2 years, and $50 for a renewal. The new act also provides further authority on the registry. In addition to the existing public registry for licensed recruiters and consultants, the new act provides authorities to publish a list of suspended license and to identify specific violations. When is a license required? A person shall hold a license to act as or imply in any manner that the person is a foreign worker recruiter or an immigration consultant or provide immigration services or recruitment services. When acting on behalf of a client, a license is required to apply for a certificate of registration, submit a job approval form, or submit a federal or provincial immigration application. All parties directly providing these services must be licensed.